Good afternoon, everybody. Welcome to Patent Basics. We are here with Matthew Grumbling with Wynn Tarbit LLC. Matthew is a patent attorney, an intellectual property attorney, and he is going to talk to us all about patents today. Welcome, Matthew.
Hi, it's good to be here.
Well, I'm going to hand the screen over to you. If anyone has any questions, you're welcome to put them in the chat or the Q&A, and we can get to them after the presentation.
Sounds good.
Okay, you should be set to go to present.
All right. So let me share my screen here. And you should be able to see that. Can you see it? Oh, you're muted. All right. So as Julie said, my name is Matt Grumbling. The topic today is patent basics, what I think every business leader should know about patents. And just to give you a little bit of background, I'm a chemist by training. I studied at the University of Arizona and then at Johns Hopkins University. And I became a patent attorney or patent agent, not patent agent, patent examiner in 1990. And I was a patent examiner in the United States Patent Office from 1990 through pretty much the end of 1998. And in that time, I learned an awful lot about patents, but only scratched the surface. I then went to law school and became a patent attorney. And I've been a patent attorney since 2001. And I've been on the East Coast. I've been on the West Coast. I've been in-house. I was in-house at a pharmaceutical company. I've been in big law, and now I'm with Wynn Tarbit. And what I'm going to talk about here is basically what I think every business leader should know about patents, or what every entrepreneur should know about patents. I think entrepreneurs are by definition leaders. They're out on the cutting edge of things, and whether they're a team of one or a team of 20 or 100, they are definitely leaders. So let's kind of launch into this. The two topics that I'm going to cover today are what is a patent, and then and that's kind of a deep subject in itself. But I'm going to talk a little bit about, well, what do you do with a patent? And primarily what I'm going to cover today is how do we research patents? How do we find out, for instance, what our competitors are doing? What kind of things what is the state of the art? You hear that term a lot. And a lot of times you can find what the state of the art is in a particular field of research or a technological field by searching the patents. And it may be the best way to do it, as a matter of fact. So the first thing I'm going to cover is maybe the most obvious, I don't know, at the most basic level. A patent is a legal document, okay? It's government issued. In fact, only the federal government of the United States has the power to grant a patent. The states don't have that power. It's been reserved to Congress. And it's been interpreted by the Supreme Court that the states don't have that power. What a patent does is it first off, is a legal document. It sets out a set of rights. It's like a contract, or in some ways it's like a title deed. And it's interesting enough, it has the properties of being sort of like property itself. It's transferable. You can assign it to somebody else. You can put it in your will, and it will pass to your heirs. Or if you don't put it in your will, it can pass to your heirs by the laws of intestacy. It is also licensable. You can allow other people to practice whatever you've claimed in your patent, and these are all subjects of later discussions. But I think that it's important to note that it has the characteristics of real property. It's also it describes what the property is. In many ways, it's like a title deed for real property. The courts have said it sets out the metes and bounds. What they mean is, that's a reference to real property where a plot of land will be described in some legally definite way, so you can tell definitely what's my plot of land, what's my neighbor's plot of land. In this case, we're mapping out property in invention space. So what's my piece of property? What do I have dominion over? And what does my my competitor or my neighbor have dominion over? And then there's, because invention space is at least conceptually infinite, there's an awful lot of there's a lot of blank space in there that nobody owns, a lot of green space, you might say. You should have a patent strategy. It doesn't really matter whether or not you are going to get patents yourself. You should know what your patent strategy is. If your strategy is, we're not going to bother getting patents right now, our technology moves too quickly, or maybe you believe, rightly or wrongly, but you believe that nobody's patented anything in your particular area of expertise or business, that should be articulated. You should have at least one PowerPoint slide that says, we've thought about this, we've thought about patents, and we don't need them. It may or may not be true, but at least you've thought it through, and you can present that as part of your business strategy. And an interesting example of this is Lyft and Uber and some of these other ride sharing and meal delivery systems and things like that. There was a time when these guys were moving so fast, they didn't have time to be thinking about filing patents and seeing them through the process and then defending them, et cetera. But now that they're established, they're out there buying up other people's patents in the field. So they had a strategy. It's just that their strategy was, hey, we're going to get going, we're going to get moving, and then if there are patents that we need, we'll either buy them or license them, and we'll get a hold of them that way. But first, we need some revenue. That may be your strategy, and that may be a winning strategy, but you should have a strategy. That's one takeaway from this presentation. So the authority for patent is found in the U.S. Constitution. It's in Article 1, Section 8, Clause 8. This is often called the IP clause. It's actually the copyright and patent clause. This is just the parts that pertain to patent. It says Congress shall have the power to promote the progress of useful arts by securing for limited times to inventors the exclusive rights to their discoveries. So those red terms there are things that I'll talk about in later slides. It's interesting to, so the term art here, think technology. In the 18th century, they used the term art as in artisanship, as in metalworking and machining and just making things. And so that's what they're talking about. They're talking about tangible, useful things. So let's talk a little bit about what the word useful means in the patent world. This was actually codified. It wasn't really codified in the law until the 1952 Patent Act. And most of today's jurisprudence around patents goes back to 1952. 1952 was a real watershed for the patent world. A lot of things that had been developed in the common law ended up being codified in the 1952 Act, and some of the things that had kind of crept in were pushed out. And I'm not going to go into that in depth. That's like an entire semester of patent law. But I just want to say that that's probably that's where everything started. There've been a lot of refinements along the way, and most of them have been very helpful to entrepreneurs. Some of them maybe not so much. But the term useful, you have to think about it in terms of practical application, real world, commercial economic application. Thinking in terms of the word technological, it's not a philosophical or a purely abstract kind of thing. It has to be real. It has to be tangible. Now, the patent itself looks very abstract. It's got a bunch of words in it, and it's a document, right? But there's actually what that document describes has to be something that's practical and tangible and useful. A good example of that would be a fission reactor. Okay, now you might not like nuclear power, or you may love it, but fission reactors are patentable. That's an important point. The Patent Act doesn't care about the morality of something or whether it's actually good public policy or not. The Patent Act is very neutral in that regard. All it cares about is that you can take some phenomenon of nature and turn it into something useful. In this case, electrical energy. What you can't patent is something like E equals mc squared, which is the sort of philosophical or abstract idea that lies behind the usefulness of a fission reactor. Einstein wasn't able to go out there and say any use of the property equals mc squared and patent that. Not that he would have, but there are individuals who might try something like that. Well, they're not allowed to. The Patent Act doesn't allow them to do that. At least it's the way it's been interpreted by the courts, and probably will be for some time to come. The actual words of the Patent Act say it has to be a process, has to be a machine, a manufacturer, or a composition. So, a process, in other words, you could use there as a method. Medical methods are patentable. Machines, a machine can be a device, it can be a widget. All it has to do is do something useful. A manufacturer could be a new kind of pot that, maybe like for growing plants in or something like that maybe is self-watering or something like that. I mean, a composition is generally, a chemical composition of some sort, some mixture that doesn't already exist in nature, but is new and again has some sort of utility to it. Let's see. So the next red line, or the next bolded term in the Constitution, is for limited times, and the Patent Act actually sets a term for patents. There's no limit in the Constitution as to what that term has to be, but under treaty, the term has been set to 20 years from the earliest filing date. So if today I file a patent application, I would have 20 years from today in order to get the patent issued and then enjoy the coverage that it provides. There are some exceptions to that, and I'll talk about them in a minute. One of those exceptions is design patents. They're 15 years from the date of issue, and it's not extendable. Okay, there's no provision in the law for that to be extended. They feel like 15 years is enough. It was 14 years, but under treaty, it's been extended to 15 years, and that's it. Some exceptions to the 20-year term, and these are all in the sense of an extension. There's patent term extensions for some drugs. Won't go into that in detail. There are patent term adjustments for delays in getting your patent. They have to be caused by the patent office. You can't be delays that you've caused if you're the applicant. There's some submarine patents. They came under the old law, going back all the way to 1995. But there are some of them that have they've been to the Board of Appeals, they've been to the courts, they've been back down again, they've been hanging there in limbo, or they've been caught up in what we call an interference, where two parties are arguing over who gets the patent. So there are some of them, and they're becoming more and more uncommon as the years go by, because the time has lapsed quite a bit since 1995. And then there's some statutory extensions. Congress can pass a law to extend a patent, and they do so rarely, and it's usually for really good cause. And I won't really go over any of those examples because they're so rare that they're hardly worth mentioning. Inventors are a very important concept for, and I just realized I'm covering that up. Inventors are an important concept for to get a hold of here, because patents are issued only to inventors. Let's see. And who's an inventor? Well, an inventor is the one who conceives the patentable idea. So somebody who actually what we call reduced to practice, who actually makes it happen. Like say I have an idea, I invent something, I write it all out, I take it to my local machinist. That machinist turns it on a lathe or whatever that machinist does, and I get back my product. I'm the inventor. The machinist doesn't have a claim from my whatever my widget is. There is no work for hire provision. Now, what that means is in copyright, you can have, let's say, Disney hires a bunch of writers and illustrators to create a movie. Generally speaking, those people are going to be employees of Disney for that period of time. And during that time, Disney owns everything that they make. And they generally will have like an employment contract that stipulates that it's a work for hire. When that's done, Disney owns the copyright. If there's no such work for hire in place, like in patents, there's no such thing as a work for hire. It has to be assigned. The patent owner in the first instance is the inventor. And so it's important for companies, if you want to own the patent, and you probably do, because I can tell you, lots of war stories about companies that haven't secured those rights, and the heartache and pain they go through trying to get a license for the invention later on. If you're paying for it, you want to get your employee or your contractor under contract to make sure that they will assign the rights to you. And that's another subject for another time. So that's the point I just made, that the employment contract needs to include a patent assignment section. So what do we mean by exclusive rights? Well, it's a right to exclude, literally. It means that you can keep other people from practicing your patent, but it's not a license. I hear this all the time from people. Now that we have our patent, we can go out and do X. Well, sometimes what they mean is now that we've filed our patent application, we can go out and do X, and there's some logic to that. But sometimes I think there's a misconception that there's something like the patent is it's a license to start selling the product, and that's not what it is at all. It is a power you have to keep other people from stealing your invention, basically, and you have certain rights in law to sue them if they are violating your patent rights. You don't have to wait to get a patent to start selling a product. It's probably a good idea it's a good idea to be very careful about the amount of time between when you start selling a product and when you file your patent application. You have exactly 1 year, and if you go a day over, you're out of luck. So you need to watch that. And best practice really is to file your patent application before you go on market. That's the safest bet. But you don't legally have to wait to get a patent to start selling a product. And like I said, you do need to be careful about statutory bar dates. You have 1 year, so watch out for that. It's not a license to do anything. You still have to get all of the applicable government approvals, and you have to comply with applicable laws and regulations. You got it. If you're selling a chemical compound, you've got to worry about FDA or EPA or maybe both. If you're in computer software licensing and things like that, you may need to worry about privacy laws. If you're running a website, you're going to have to worry about things like the ADA, the Americans with Disabilities Act, for accessibility and all sorts of things. There's just the patent gives you the right to exclude others. It doesn't give you a positive right to do anything. But kind of one of the most powerful things about a patent is that it's a technical document. And if you look at a patent, it's actually a tremendous repository of state-of-the-art information. And think about this. There are over 10 million issued patents and pre-grant publications. And really, when you add together patents and pre-grant publications, you're well into the probably 11 or 12 million or more application or publications that are out there. Then you add in the tens of millions of worldwide patents, and they cover just about any technical subject you can imagine. So, and the greatest part about it is, for a lot of jurisdictions, they're free. The US, Europe, the World Intellectual Property Organization, and several other organizations, the European, I guess I mentioned the European Patent Office, they're all free. And you can learn a lot about a subject from just looking at the patents. It may not be as well organized maybe as a textbook or something like that, but they're free. And you can get a lot of competitive intelligence. If you're in a technological field and you're thinking about doing something, you might want to look at what your competitors are doing. What have they filed applications on? And kind of importantly, what are they not doing? We call that freedom to operate, but basically, but it's also, it's breathing room, right? If your competitors aren't in a particular space and you see a need there, that's an opportunity. And so, you can learn a lot from patents, and a little bit later, I'm going to show you how to do that. And I just thought I'd show you this face of a patent and kind of talk about what the different parts are. If we look up here in the top left, we see Edwards et al. Edwards is the last name of the first named inventor. It's hard to read it here, but it's Reginald Harold Edwards. And then the et al. Just means et others. The title of the patent is pneumatic tires in this particular case. The number up here in the top right is in the 3 millions. That was back in 1976. That's the issue date. Here we see the original assignee of the patent. That's who owned the patent. That means that these folks here all signed some sort of document giving ownership of the patent to Dunlop. If there are any related applications, a related application is one that, generally speaking, at least on the face of the patent, it's always either a continuation or a divisional or continuation in part. And these are applications from which they claim priority. So the original filing date was in 74. I know that's hard to read there. We'd have to go back one, but here we can see that there was an earlier application in 1973. Now, when this was issued, the term would have been 17 years from the date of issue. But nowadays, this date here would limit it. It would be 20 years from this date. So you would have, what's that? 1993 is when it would have expired. And in this case, it would be probably about the same. But and then there's a lot of other information down here. There's classification. There's an abstract over here, which you'd be familiar with from journals. And then they even show you who examined, which examiner examined this. So every examiner knows that when he or she issues a patent, it's going to be out there in the public that they've done it. So here, I thought I'd show you what a claim is. Now, a claim is the most important part of the patent from an enforcement standpoint. It's the only thing that counts is in terms of property, because it's like the title deed of a piece of property. So I'm not going to read this whole thing to you, but just to kind of show you, there are several parts to the claim. Each of those parts is important. If you accuse somebody of infringing this patent, they have to do everything that's in this claim. So if you're the patent owner, you want the claim to be as short as possible. You want it to have as few limitations as possible. As the more limitations there are, the more ways somebody could say leave out a part. You might say, like if you look down here in E, the other part being carried out on the interior surface of the assembly. If you could find out how not to do it on the interior surface of the assembly, then you would avoid that patent. Here I've circled or boxed in a claim term. So each part of this claim is a claim term. Here it says assembly having means to prevent the tire beads from becoming dislodged from the rim when operated in a deflated condition. So these are run flat tires, and this is just a way to keep the tire on the rim so that it doesn't break off and roll off when the tire deflates. Kind of a cool thing. Here in the specification is basically a dictionary of the terms in the claims. So if you're wondering what a means for something or other is, you can go and you can read the specification to find out what that is. And the specification should be definite enough that a person who has ordinary skill in the art, whatever that is, will be able to read it and know how to put it into practice. Here are some figures where the terminology is where the technology is amenable or admits to illustration. There should be figures, and there are some cases, let's say medical methods of treatment and things like that may not have illustrations, but where possible, where it's possible to illustrate, say, a machine or a widget or even a process, you can do a flow diagram or something like that. You're supposed to have figures in there, and you'll get an objection from the patent examiner, and you'll have to tell them why you don't need figures if let's say you're claiming a machine and you don't have any figures. So the last thing that a patent is, and this is very important, it's a defensive document. It's important to note that they are published 18 months after filing, unless you request non-publication. It is prior art from its filing date. What does prior art mean? It means that it's evidence that you invented it first. And if, say, somebody files after you do, let's say I file a patent application, say I filed it on January 2nd of this year, and somebody else files one today for the exact same thing, I win because I have this defensive document. If somebody tries to sue me later on for a patent that, say, mistakenly issues because of a later filed application, I can pull out my earlier filed application as evidence that I invented it first, and in fact it wasn't new when they got their patent. So publication can actually block a competitor from obtaining patent coverage, not only here, but worldwide. So that's an important thing to keep in mind. Some folks, they don't want to spend the money on a patent. They don't see what good, we're never going to sue anybody, blah, 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 blah. Well, if you consider the defensive power of the patent, if you consider the fact that just having it published protects you against somebody later on patenting it and then coming after you for infringing their patents, it's kind of a powerful thing. So the important thing here in this bullet point is that publication has worldwide effect for creating prior art or defensively. A patent, however, only counts where you file it. So if you file it in the United States, you would have to perfect those patent rights worldwide by complying with the filing laws in the other countries and actually prosecuting them through to the point where you get a patent. So the next question up is, how do I research patents? You know, and kind of a question you want to ask yourself is, you know, what do you want to know from patents? And I'll talk about some of the things you can find out from patents. But let's just talk about patent searching. Back in the day, we mostly went to depository libraries. They were published. They were published patents. They kept them organized by patent number. They had ways of searching for them, and they, I honestly don't know how they were organized. When I was in the patent office, we had printed patents, and that's the primary way we searched. And they kept them organized by classification, and then we just flipped through them. Honestly, we sat there in what we call the shoes, and we flipped through them. Nowadays, they have online databases, and the USPTO has one. eSpace is run by the European Patent Office. There's an excellent platform offered by Free Patents Online, and then Google Patents is another source that you can use. There are also private online databases. There are lots of them. These are just some examples. So here's some of the free databases. The USPTO, it has patents. It has pre-grant publications. Those are those 18-month patent applications. And then you can also check patent status. You can check pair. You can check assignments. And one that I don't have on this slide is, and I'll show you though, is status. We can find out whether, because you have to pay maintenance fees to keep your patent alive, and you can search for whether somebody has paid their patent maintenance fees. Then some of the other ones are Free Patents Online. I encourage you to check that one out. It's very nice. eSpace has some nice properties to it. And then Google Patents is a good one. So let's just talk about doing a USPTO search. So primarily, this is a text search database. The text search goes all the way back for the pre-grant publications, goes back to 2001, March of 2001. You can do Boolean, you can do number searches, and you can do quick searches. A number only works if you already know what the number is. Boolean, you can use A and B, A or B. And then you can do so-called quick searches, and there are images available. So let me see if I can click over and show you that. Let's go here. So what I've done here, and I can go here. Let's say I go here and I do a number search. Let's say I know what number I want. I'm interested in seeing what patent number 10 million is. So I search 10 million, and there we get, there's 10 million, and this is all text. There are no images embedded in here. And where there are like special characters, they have special ways of showing you what those characters are. If you want to take a look at the image itself, you can click on Images, and you can see this is the front page of the patent like we looked at before. If I want to look at the claims, just the claims, I can click Claims over there on the left-hand side. I want to make it a little bit bigger, I can click on this plus sign. If I want to look at all the pages, I can click Full Pages over here. And I can even print them or download them as a PDF. You can see, there we go. And you can see it doesn't put in the patent number, so you've got to type in something like and there we go. So that's how that works. You can do the same thing in this is the home page for the patent searches. You can do the same thing over here in pre-grant publications. I don't know the number, but let's say I want to search, go back to the subject we were looking at before, pneumatic tires. Got to remember the Boolean operator. And you have to remember that the British spell tire T-Y-R-E, and there's an awful lot of art you would miss if you didn't spell it T-Y-R-E. Do a quick search on it. You can see there's 16,639 patents. Now, let's say I want to limit it to claims. There's a place you can go to look at what codes you need to put in order to search just the claims. But here, so I'm saying pneumatic can be anywhere in the patent, but tire or tire has to be somewhere in the claims. And look at that, we got ourselves down to 10,866. Obviously, we'd have to narrow that quite a bit to have a reasonable search there. But let's just pick on one of them. Let's take a look and see where this one is in the process. So here's the serial number down here. It says serial number or application number is down here. And let's go over to Public Pair. Public Pair is a free service from the Patent Office, and you can learn a lot about patents by looking through Public Pair. So here we're searching it. Oops, it didn't come up. Probably because I put in the wrong thing. Let's try it again. Application number. It says it. Okay. There we go. Sometimes it takes a couple of times to make it actually happen. So what this allows us to do is check on the status of the patent. So it turns out this application has actually issued. Well, it hasn't issued, but we can see over here it's in publications and the issue fee payment has been verified. We can click on this tab here and we can see every transaction that's happened in this patent. It's very comprehensive. They record every single thing that happens to this patent application that's of note. This one, which is the image file wrapper, is every communication that goes between Patent Office and the applicant and the Patent Office. So you can look down through this and you can find the original specification, the original claims. If there have been any references cited, there's a list of references cited by the applicant and considered by the examiner. You can download parts of this as a PDF just by clicking that and clicking PDF, or you can download the whole thing. It's really nice. I mean, back in the day, you had to either hire a vendor to go over to the Patent Office and copy the actual physical file, or you could go over there yourself, which was really fun. And I did that on more than one occasion. So it's this is awesome. You can download. If you see something your competitor's doing, and you see that over here in the publications, and you want to find out, well, did that patent ever issue? Well, you can find out about in Public Pair. Sometimes you might find out, no, actually, they didn't get it, and that would be great news for you. Assignment. Now I can click here on the Assignments tab. This is usually pretty correct. I haven't seen too many discrepancies in it, but let's just say for the moment, I'm going to go back here to the application data. And well, this one may have an assignment recorded for it. Let's skip that one. Let's do something different for assignments. So I'm going to do a quick, this one I know there's an assignment for. 7,500,000. I click that. And it takes a moment. Maybe I didn't click it. Oh, I need to select this. That number. There we go. There we go. Oh, that came up quickly. So now we can see this patent that I typed in has been assigned. It's been assigned from these inventors, and it's been assigned to International Business Machines Corporation. So you might be interested in looking at what that patent number looks like. Whoops. So I'm going to go to Home. I'm going to go to the number search. Let's try it again. There we go. And one too many zeros in there. Okay, so there's 7,500,000. And let's say that's something I'm interested in. Let's say I read through this and I see a computer storage medium tangibly embodying a program of machine, a SAN host, and I go, oh no, this sounds like it might be a problem for me. Then what I will do is I will go over to see if it's still in force. And the way I check that is I go to the fee database. Okay, these are all in the slide deck, and if you need a copy of the slide deck, Julie will provide it for you, or I will. So there's the patent number. You also have to provide the application number, which I copied previously. And it's always good to take out all the extra characters just because you never know what's going to happen. And here I breathe a sigh of relief because I find out back here when it should have been renewed back in 2012, it wasn't. So the maintenance fee wasn't paid. It's been unpaid for quite a while. It's not coming back from the dead. I breathe a sigh of relief. So that's kind of the basics of patent searching. There are, you can take a deeper dive. Here I've provided the URLs for repair, assignments, and maintenance fees. You can also do Google Patents. By the way, you can Google all of these things. It's probably the quickest way to find most of these things. Freepatentsonline.com is freepatentsonline.com. That's real easy. eSpace is, again, it's worldwide.espace.com. And so the next time, what we'll talk about is patent eligibility. And can I even get a patent? Is my ID even eligible for patenting? And we'll talk about, particularly where it applies to computer software, but we can also talk about things like natural products and those types of things. So with that, I think I will hand things back over to Julie if I can figure out how to do that. Or maybe she can just turn that off.
You're okay. Thank you very much. That was very, very informative. And I know if you want to tune in next Tuesday at noon again, we will have part 2, which is patent eligibility, which Matthew just stated, and a potential stumbling block for programmers and others. So if you missed any part of this recording or this webinar, I will post it up on our website so you can go back and view it again. If you would like a copy of the PowerPoint, please email me at julie.neal, and that's N as Nancy, EAL, at surpriseaz.gov, and I'm happy to share that. And also, if anyone has any questions, feel free to, I'll give you a minute to put something in the chat here, and then we can kind of go from there. I'm not sure if we have any questions. So what I will do is just thank you very much. We really appreciate your time. Great presentation, and we look forward to seeing you next week.
All right. Thanks,
Have
Julie.
a great afternoon.
All right.